Right, so let's start. So what was our earlier discussion, ma? Resignation and completed a resignation and removal. I think I have to discuss resignation and removal. Removal also completed, huh? How you will remove a director before the expiry of the term? By passing a special resolution. Removal. Removal is not a normal thing, it's an extraordinary thing. That's why you need no special resolution. Pakka. Appointment needs special resolution. Both are ordinary resolutions only. God bless you. God bless. Okay. So after removal, I think remuneration we have to discuss, right? Remuneration of directors. Okay. So very good, ma. Remuneration of directors. It's a somewhat complicated thing, but not a difficult one. Why? Because when it comes to remuneration, we have to refer section 197 read with schedule 5. Schedule 5. In that schedule 5, two parts will be there. Part 1, part 2. Part 1, which talks about appointment of managing director or whole-time director or manager, whoever it may. Appointment of managerial persons. Schedule 5, part 1. Appointment. In the same schedule 5, part 2 is there. Schedule 5, part 1 about appointment of managerial persons. Schedule 5, part 2 talks about remuneration payable to directors. So how you can pay remuneration to director? So first of all, we have to discuss about appointment. That means schedule 5, part 1. So with respect to schedule 5, part 1, we have to discuss. After that, let's indulge in the discussion relating to remuneration. How we should pay remuneration? Is there any sublimits applicable for the remuneration? And what are all the sublimits, if any, in case of profits, in case of losses, and conditions attached to the maximum remuneration? How members will play a key role in the increment of these sublimits, and all we will discuss. So let's talk about Schedule 5, Part 1. Schedule 5, Part 1. Part 1 talks about appointment. Part 2 talks about remuneration. AC remote ఎవరి దగ్గర ఉందా? 24 బెట్ అండ్ 27 బెట్ ఫోన్లో హ్యాక్ చేశారా? ఎత్తుకెళ్ళి హ్యాకర్సా మీరు? ఓకే రైట్. అండ్ టేస్ట్ ప్యాకేజ్ ఆఫ్ ది డికేడ్ ఇచ్చేస్తారులేండి. నువ్వేనా హ్యాకర్? 24లో పెట్టమ్మా. ఓకే. సో let's talk about schedule 5 part 1. Schedule 5 part 1, which talks about remuneration, appointment. Schedule 5 part 2, remuneration. Okay, so I have already and all this. Yes, this is the one. Schedule 5 part 1 and part 2. Okay, so schedule 5 part 1, what? Appointment of MD, managing director, whole-time director, manager. Appointment of MD, whole-time director, manager. Okay, part 2, remuneration payable to so-called MD, whole-time director, manager. Okay, so there is a typical difference between this MDWTD and manager. Same MDWTD and manager. One of the difference I have already communicated in the previous class. I said that in order to protect managing director's position, or in order to secure the job of managing director or whole-time director, there is a chance for the company to exclude them by saying so in the articles of association or in the employment terms agreement or in the recruitment agreement will be there, no? In the terms you can exclude them. There is a chance. Unless otherwise stated, they will also include in that rotation sheet. Everything is silent. Why? Because they are also directors, right? Managing director, whole-time director. But there is a provision in Companies Act which will exclude them from this rotation process, retirement process, and secure the job of the so-called executive persons. Why? Because they do have lot of long-range plans which they are going to implement in coming 2 years, 3 years, 4 years. Like, if you remove them from the company, those implementation plans will be uninterrupted. That is why for the uninterruption of that long range plans and all, there is a provision. Like an exception, we can consider it. So unless otherwise stated, tell me the rule. Unless otherwise stated, what will happen? They will also include in this rotation, no exception. Whether they will include or not depends upon the recruitment agreement or articles of association and all. Why an exclusion should be provided for that kind of executive persons? Reason I have already communicated in the previous class. Some students will ask, sir, why they will include in that rotation process? Why they will include means they are directors only, no? They are directors, that's why they include. Whom you will exclude from the rotation process, tell me. One, independent director you will exclude. Nominee director, small shareholder director, additional director, alternate director. In this 5 list, MD is there, WTD is there. So why? Because they are by default they are included. Whether you are going to include them or exclude them depends upon your behavior. That means your company's behavior. That is a different thing. I have already communicated this. Second point is there, which I am going to tell you now. There is a huge difference between MD and manager. Both are executive persons only. MD and manager both will include in the day-to-day affairs of the company. Both will manage the affairs of the company. Both are having substantial powers of the company. But there is a crucial difference between manager and MD. What is the difference? Is manager is not going to take any part in the board, but MD is going to take part in the board. That is the difference. MD is a director appointed by shareholders in the general meeting. Repeat. MD is the person who is appointed by members in the general meeting. But whereas manager is not appointed by the members in the general meeting, manager will be recruited by BOD in general case. Reality, manager will be recruited by BOD. Manager will not get any sort of appointment process and all from members in general meeting. That is one of the crucial difference. Okay, but being he is participating actively in the day-to-day affairs of the company, whatever the remuneration process, whatever the appointment process will be purviewed by Schedule 5, Part 1 and Part 2. Part 1 appointment process, Part 2 remuneration process. Are you getting the point? There is a substantial difference between MD and manager. Kindly note this point. And whatever the point which I have communicated earlier in the previous session with respect to exclusion relating to rotation process and all, that is an exception, not a by default rule. That is a exception. Okay, there is a way to do so. That is not the default way. Kindly note the difference. Okay. So let's talk about part 1, appointment of MD, WTD, manager. WTD, whole-time director, he is also an executive person. MD, obviously executive person. Chairman, not chairman. Who is a person? Manager. So these 3 persons appointment will be reviewed by Schedule 5, Part 1. So listen, very simple thing. First of all, before you are appointing managing director or manager or whole-time director of a company, you have to check one thing. Check whether they are complying the rules and regulations which are stated in Schedule 5 Part 1. Schedule 5 Part 1. So, with respect to appointment of MD, WTD manager, okay, apply the rules purported in Schedule 5 Part 1 to the so-called appointees. Say for example, I am considering Mr. X profile as whole-time director of my company, Mr. Y profile as managing director of my company, Z profile as a manager. Okay, simultaneously MD and manager should not be there, I'll tell you later. So I'm considering few persons profiles in order to appoint them as MD or whole-time director or manager of my company. So before I'm considering their profiles, I have to check whether these persons are satisfying conditions mentioned in Schedule 5 Part 1. Sir, what are the conditions mentioned in Schedule 5 Part 1? Very important. What are the conditions mean? These are the conditions. First one, no imprisonment or no penalty greater than 1000. According to some list is there, ma. Total 16 acts will be included in that list. It is none of your business to know about what are all those 16 acts and all. Insolvency, Bankruptcy Code, Competition Act, Customs, Income Tax Act, Wealth Tax Act, SEBI, SCRA, Securities Contract Regulation Act. Few acts will be there. I can say though that 16 acts list and all, but it is not there in your curriculum. Unnecessarily, you no need to remember all the acts names and all. So you have to remember some acts are there. Forget about 16 and 17. Some acts are there. According to those acts, these persons means persons whom we are considering for the role of manager or WTD or MD. For these persons, no imprisonment in past period. Not even a single day. Forget about 1 month, 6 months, 7 years. Forget about time period. Not even a single day. Sir, I am considering Mr. X profile, sir. Mr. X is a recently released convict, sir. Why he went to jail means committed an offense under the so-called 16 Act, sir. That's why he went to jail. Now, can I appoint Mr. X as managing director of company? Automatic appointment not possible. Okay, this one you have to note this one. We can appoint, but there is a different route, CG approval route. Who is CG? Central. That is a different thing. I'll tell you later. As of now, we have to check whether these guys are satisfying these conditions or not. Sir, if they satisfy, okay, straight away we can appoint them as MD or manager or full-time director, whatever it may be. It is in our hands. The appointment process is in our hands. We can appoint. No one is there to object us. Okay, sir, that person went to imprisonment. That person recently released from jail. He committed an offense under the so-called 16 Acts. Or recently he didn't went for jail, but penalty imposed on him beyond 1000. Now what is the position? You can't appoint that person as MD or manager or whole-time director. There is a different route. What is the different route means? You have to take the central government approval. Central government may question you. Why you are appointing this fellow as managing director of your company? Do you know the track record of this fellow? He recently released from jail. So likewise, central government may ask the questions. You have to be ready with the justification. You have to be ready with justification. If your justification seems okay, then only CG will give approval. Otherwise, CG may not permit you to consider appointment and all. So listen, one of my friend is there. He committed an offense under the 16 Acts and went to jail and released recently. I am considering his profile for the post of MD of my company. So, am I allowed to appoint that person to the position called MD straight away? Means no. There is a possibility. There is a way. There is an alternative way to appoint that person as MD to my company. But what is that way? Is approval route, not automatic route. Which route is available? Approval route, not automatic route. Automatic route means I will appoint. No need to get anybody's permission. I can straight away appoint, automatic route. But being he went to imprisonment or he is penalized with more than or equal to 1,000 and all according to some acts. That is why not allowed to appointment for my company as MD or manager or WTD in automatic route. In which route? Automatic route. In which route he will be allowed? Approval route. Whose approval we have to take? Central government. Will central government will straight away give approval? No. Central government may give approval, may not give approval. Central government may ask questions. One after another. May ask questions. Sir, even after giving proper justification, is there any guarantee that CG may allow me to appoint such person as MD? Depends. Depends on shareholders' interest, depends on public interest, depends upon your company's track record, how frequently you are deviating the law, how frequently you are filing the returns to ROC, income tax department, GST returns. Depends. It all depends. Case to case. We can't say straight away that CG has to give approval. Who said CG has to give approval? CG may give approval. CG has to give approval. CG may give approval. Both are not same. CG may give approval means the ultimate authority is whom? Central government. May give approval, may not give approval. CG has to give approval means you are commanding central government. No, it is not possible. You are not in a commanding position. You are in a requesting position. You have to seek the prior approval of central government. CG may give approval or may not give approval. This is first condition. Are we clear? The person should not be awarded with any imprisonment so far. Forget about period. 1 day, 2 day, 3 days, 6 months, 3 months, more than 6 months, up to 7 years, more than 7 years, nothing. That is 164 disqualification. Do you remember the time periods and all? 164 disqualification. Okay, right. Okay, right. I'm satisfied. So, but here, no time limit ma. Even a single day is enough. Even a single day is enough. A person went to 2 days imprisonment. In his lifetime, he is not satisfying Schedule 5, Part 1. Whenever a company is considering his profile for the role of MD or manager or WTD, it has to take the approval of central government. Okay, this is first point. Or no penalty greater than or equal to 1,000 according to 16 acts. Some acts are there. Out of the tax, few acts are there in your syllabus also. SEBI is there in your syllabus. Competition Act is there in your syllabus. SCRA is not there in your syllabus. CA final is there. Securities Contract Regulation Act. Income tax is there in your syllabus. Wealth tax unda meeku DT lo? Wealth tax leda. Okay, right. Few customs unda IDT lo unnattu. So customs. So few acts are there. So you must not commit any offense under these 16 acts. And yes, sir, I committed an offense. I committed an offense under these 16 acts. Penalty 500 levied. Imprisonment not levied. Tell me, are you satisfying Schedule 5 Part 1 or not? Are you satisfying Schedule 5 Part 1 or not? Yes, you are satisfying. Ma, use the brain. What I am saying, no imprisonment, no penalty greater than 1,000 or more. What I have stated in the example, penalty, you committed an offense under the so-called 16 acts. Ma, okay, very good, congratulations. The penalty is 500 only. No imprisonment, not even a single day. You didn't went for jail. No imprisonment. Penalty levied, that to 500. 500 is less than 1,000. That is why This point is not applicable in your case. You are still satisfying Schedule 5 Part 1. You are still satisfying Schedule 5 Part 1. Kindly understand the point to the fullest scenario. This is first point. Clear? First point clear? Second point, no detention under COFV POSA, Coffee POSA Act. Okay. What is Coffee POSA? Conservation of Forex and Prevention of Smuggling Activities Act 1974. There is an act, Coffee POSA Act. So, మీరు కాంపిటీషన్గా టీ పోసా పాలు పోసా అని పెట్టండి. సో కాఫీ పోసా మీన్స్ CO, కన్జర్వేషన్ ఆఫ్, FE, Forex. Conservation of what? Conservation of Forex, foreign exchange. Forex means obviously foreign exchange. And prevention of smuggling activities. Prevention means encouraging. Prevention means what? Encouraging or stopping? You students are in dilemma. Prevention. Prevention means what? Stopping or encouraging? Stopping. Prevention of what? Smuggling. POSA, Prevention of Smuggling Activities Act 1974 is there. So you should not be detained under this act. Should not be detained under this act. Sir, I detained under Coffee POSA Act, sir. Okay. You said to be you are not satisfying Schedule 5 Part 1. Okay. Third point, age 21 to 69. If your age is 70 or more, you are not satisfying Schedule 5 Part 1. But for age limit, there is a point, central government recently, not recently, few years ago only, central government delegated this authority to shareholders. Why? Because discriminating a person just because he is having more age is not proper. In order to appoint that kind of old aged person, you are supposed to ask central government permission and all, is somewhat not fair. Mundu puttadam vaadu tappa kaadu. So that is why central government recently, few years back, not recently, delegated the power to shareholders, saying that, okay, if any person aged 70 or above and you are considering his profile for the appointment as MD, manager or WTD, whole-time director, as per rules you have to ask my permission. Who am I? Central government. Okay, as per rules you have to ask my permission, but I'm relaxing. Why? Because he is not committing any offense or something. Just because his age is more, you are rerouting his appointment for the CG approval is not fair. That is why we are giving the power to shareholders. That is why, in order to appoint a director, which resolution is sufficient? Ordinary resolution. But in this case, special resolution is required. In case of appointment, I have already told this point. చెప్పానా చెప్పలేదా? ఎవడు తెలుస్తారు అంటారు మీరు. చెప్పానమ్మా మీకు. Listen. MD, WTD, manager, minimum 21 age. Actually, no specific age limit is purported for qualification of director. 18 plus is enough. Minimum 21, max 70. If greater than 70, SR is needed. But listen, there is a ambiguity between 70, up to 70, or more than or equal to 70. But for fair methodology, we are considering up to 69 only. If the person is 70, is 70. Why? Because age can't be measured in fractions, right? How much is your age? Means 70.2, 70.3. In that way, either 70 or 71. That is why we are considering up to 69 only. And 70 or more, they used to reroute the appointment for approval route. That means CG approval route, central government approval route. But now central government delegated the power to whom? Shareholders, and saying that we don't take care about that activities and all. You please take care of about the appointment of the so-called persons, and if the MD's age or manager's age or executive, I mean whole-time director's age is 70 or more, for normal director OR is sufficient, ordinary resolution is sufficient. But in this case, we are insisting you to pass special resolution. So, if special resolution passed to appoint the MD or manager or whole-time director, it is enough. Normally, OR is enough, but in this case, being the age is more, SR is required. Which is required? SR, special resolution is required. Are we clear? So, we are considering the points relating to Schedule 5 Part 1. We are not into the discussion of Part 2. Part 2 means remuneration. We are still discussion of appointment only. Schedule 5 Part 1. Every director's appointment. No, 3 persons only. MD, WTD, manager. Very good. So, no imprisonment or no penalty more than 1000 according to 16X. No detention under coffee posa. Age 21 to 69 and must be resident of India. That means if you are considering a foreigner, you are considering anything to say? Someone is talking. Okay, so listen, pay attention properly. So, what you are discussing? Resident, yes, listen. So, you are considering a foreigner's profile for the appointment of MD or WTD or manager. Not possible. You have to reroute the application through approval route. Automatic route appointment is not at all possible because he is a foreigner. Ain't foreigner aithe he is not satisfying the points mentioned in Schedule 5 Part 1. What is the point mentioned in Schedule 5 Part 1? He must be resident of India. If he is a resident, then it is a different case. If he is a resident, then it is a different case. You can appoint him through automatic route also, no problem. Do you remember I told you about resident director? For the appointment of resident director, foreigners also allowed. All you need to do is to satisfy resident condition, more than 182 days condition. That is the only point. M1. So, these are few points. And apart from this, listen, certain disqualifications are there. Certain disqualification. But these disqualifications are not mentioned in Schedule 5 Part 1. Schedule 5 Part 1 over. Whatever the conditions that are communicated in Schedule 5 Part 1, I have already communicated. These are the Schedule 5 Part 1 conditions. But position of MD is very powerful. Why? Because he is going to have what kind of powers? Substantial powers. That is why position of MD is very powerful. That is why, listen, that is why in order to appoint a person into the place of MD or WTD manager, apart from 164 disqualification, kindly don't ask what is meant by 164. Do you know 164, right? 3 levels of disqualification: personal disqualification, company level disqualification, AOA disqualification. Thank you. So apart from this 164 disqualification, there are certain points which a person need to satisfy exclusively for the position called MD, WTD, manager. That means if you satisfy 164, it is okay. You can be appointed as a normal director, but you are not a normal director here. We are considering you for the role of MD or manager or WTD. That is why you have to satisfy few more additional conditions. So what are the few more additional conditions? Listen, all conditions as per 164, very good. 164.1, 164.2, 164.3, and means along with 164 satisfaction, You have to satisfy these two conditions. So what are these two conditions? First one, not suspended payment to creditors or entered into composition scheme with creditors. Listen, if you are entering into a composition scheme with creditors, when you will enter composition scheme with creditors, what is meant by composition scheme? First of all, tell me. Composition, ma GST composition scheme limit చెప్తున్నారా? See, composition scheme is not related to GST provisions or income tax provisions, ma. In this scenario, composition provision mean or composition scheme means you are unable to discharge the whole debt that is due to creditors, and that is why you are asking the permission of the creditors to accept few bucks in the place of full and final bucks. Say for example, I owe 10 rupees to a creditor. I am requesting the good selves of the creditor saying that, sir, I am unable to pay 10 rupees, sir. I will give 6 rupees, sir. Please consider this 6 rupees as 10 rupees, sir. That means I am not going to pay remaining 4 rupee. Please consider this 6 rupees as full and final satisfaction. Please consider this 6 rupees as full and final satisfaction. That is what we call composition scheme. Composition scheme means you are in a your company is unable to discharge the whole debt that is there due to creditors, and thereby entering into a composition scheme with creditors. That is what composition scheme in this scenario, not GST composition or something else. Okay, kindly listen. Okay, clear? Sir, what will happen, sir? Okay, one of the director is there. The director is acting as MD of a company, and during his tenure, that company entered into a composition scheme with the creditors group. What will happen? If you are entering into composition scheme with the creditors, it indicating your inefficiency towards the administration of the business. It is indicating your inefficiency towards the administration of the business. And how far shareholders will trust you? It is in the best interest of the company to avoid your profile. Why? Because we can't delegate substantial powers of the company to a person like you. Sir, what kind of person am I? You entered into a composition scheme with creditors earlier. Or listen, you suspended the payments to creditors. That means you failed to discharge the debt which is due to creditors. It is indicating your administrative inefficiency. Administrative inefficiency. That is why that kind of person should not be considered for the position of MD or WTD or manager. You may appoint such kind of persons as other directors, non-executive director or something else, but you can't consider their profile as profiles for the position of MD WTD manager. Are we clear? Second condition, that person should not be convicted for a period of 6 months or more. General conviction, not according to 16 acts, 17 acts, 18 acts, nothing. General conviction. General, any act. It may be due to any act. So general conviction, how much ma? 6 months or more. Sir, what will happen if the conviction period exceeding 6 months or more? You are unfit. You are unfit, disqualified, no CG approval, nothing. Why? Because it is disqualification, not Schedule 5 Part 1. For not satisfying Schedule 5 Part 1, there is a route. For disqualification, there is no route. Whatever happened is happened. You can't change it. That is why we are not considering your profile as profile for the role called MD WTD manager. Lawmaker's intention is very clear, ma. Substantial powers should be allocated to genuine persons and responsible persons only. Why? Because they are in the driving seat. They are the persons who are responsible for the growth of the company or further directions of the company. If you put the substantial powers into a genuine person's hand, the company will be multifolded. Otherwise, what is that? Daivadinam bus service. What is it? Daivadinam for service. వెళ్తే వెళ్తుంది లేదంటే పోతుంది, సింపుల్. సో లా మేకర్స్ ఇంటెన్షన్ ఇస్ టు appoint only responsible persons, clean recorded persons into the position of MD or WTD or manager. Okay, so now nothing, we didn't intimated or communicated anything, we just learned two conditions, that's it. We just learned two conditions only. Forget about appointment termination, nothing, forget about everything. We communicated only 2 points now. What are those 2 points? Means about schedule 5 part 1, that's it. About schedule 5 part 1, that is point number 1. About what? Schedule 5 part 1. Schedule 5 part 1 talks about, okay, this is a bonus point. You still remember that schedule 5 part 1 talks about appointment of MD or WTD manager. Very good, the bonus point. So you know about schedule 5 part 1, right? A person said to be in satisfaction or in compliance with schedule 5 part 1 when there is no imprisonment, not even a single day, or no penalty greater than or equal to 1000 according to few acts. According to few acts. That is point number 1. Point number 2, should not be detained under COFEPOSA Act, Conservation of Forex and Prevention of Smuggling Activities Act 1974. And the third point is about age, 21 to 69. And fourth point about resident. Okay, so these are the 4 points. So they will check these 4 points before appointment process. Sir, very good, I satisfied all these 4 points, sir. Very good, you are fit for appointment in automatic route. Which route? Automatic route. This is point number 1. Say for example, you are not in satisfaction with schedule 5 part 1. You are not complying the rules mentioned in schedule 5 part 1. You are straight away disqualified, huh? No, there is a alternative route for you. What is that alternative route? If company still wants to appoint you as MD or manager or WTD, there is an alternative route, approval route. What is that alternative route, ma? Approval route. Whose approval company has to take? Central government approval company has to obtain. Then only their appointments will be valid, or their profiles considerations will be valid. Forget about appointment. This is schedule 5 part 1. This is point 1 which we learned today. Are we clear? Are we clear with schedule 5 part 1, which talks about appointment of MD, WTD, manager? And as a second point, we also learned few disqualifications which will exclusively applicable for the person's MD, WTD, manager positions. Sir, what are the exclusive disqualification? Whatever the disqualification that are mentioned in 164 section, it is full and final. Okay, those are all you have to satisfy. You must not be disqualified as per that rules and regulations 164. Along with satisfaction of 164, for 2 more points also you must be in compliance. Sir, what are those 2 more points? Point number 1, you must not suspend payments to creditors, or you must not enter with any sort of compromise or composition agreement with your creditors. Why? Because if you suspended the payment to creditors, or if you entered into a composition agreement with the creditors, it indicates your administrative inefficiency. That is why that persons are not allowed, disqualified. Now students will ask few doubts. Sir, in 2010, this, which year? This is 2025, right? In 2010, that is 15 years back. 15 years back, I entered into a composition scheme with the creditors. Now what will happen? Still am I disqualified? Yes. Actually, there is no time limit mentioned in the ACMA. That is why, even though you entered into a composition scheme with creators 15 years back, 20 years back, 25 years back. Usually 5 years cooling off period will be there. Even though you went for imprisonment and all less than 7 years, from the date of release, 5 years you are disqualified. In the case of 188 also I have told this point, related party transaction offense. If you convicted under section 188, from that conviction date, 5 years you are disqualified. Like that, here no time limit is mentioned in the act. That is why even though you entered into a composition scheme long ago, at that time if you are MD of that so-called company or manager of that so-called company or WTD of that so-called company, you are not allowed to act as MD, WTD, manager of the company. Not only for that company, for any other company in future also, you are not allowed. That is point number 1. Point number 2, conviction for more than or equal to 6 months. Sir, convicted, sir, what will happen? You may be qualified for the role called any other director, but you are not qualified for the role called MD, WTD manager. So this is about basic qualification for the role called MD, WTD manager. Are we clear? So schedule 5 part 1 talks about appointment of MD, WTD manager. Schedule 5? Schedule 5 part 1. So we saw the schedule 5 part 1 conditions and we saw the few restrictions applicable for the position called MD, WTD manager. Clear? Are we clear? Can we proceed further? Thank you. So now let's get into the process. Very important one. Listen, ma. Schedule 5 part 1 satisfied. Schedule 5 part 1 satisfied. Very good. That person is satisfying schedule 5 part 1 and he is not disqualified as per 164. Didn't enter any compromise arrangement with creators. Didn't underwent any imprisonment for period more than or equal to 6 months and all. Satisfied. Now, if the appointment is carrying out by members in the general meeting, don't ask which general meeting, any general meeting. It may be AGM or it may be EGM, annual general meeting or emergency general meeting. What is EGM? Extraordinary general meeting. Okay, so AGM means annual general meeting. EGM means extraordinary general meeting. Okay. What that guy is doing? Oh, you are writing, huh? Okay, carry on. So AGM, EGM. So listen, schedule 5, part 1. You satisfied? Very good, congratulations. And now members are considering your profile for the so-called role MD, WTD manager. Yes, they can appoint you as MD or manager or whole-time director. Why? Because you have clean record. You have what? Clean record. So by passing a ordinary resolution, members can appoint you as a MD or manager or whole-time director. OR na? SR? OR or SR? For appointment of directors, which resolution you are passing? Ordinary resolution. Special resolution, age-wise MD is 70 or more. That is a different thing. Okay. Now listen. Sir, appointment is not carrying out by members in the general meeting, sir. BOD is looking after the appointment, sir. Board of directors are looking after the appointment of MD, WTD manager. Now listen. First of all, by passing a board resolution, don't ask which board resolution. Ordinary board resolution, special board resolution. That kind of classification is there in board resolution, ma? No, I have already made it clear this point in earlier sessions itself. So in case of board resolution, only board resolution will be there. Listen, if appointment is carrying out by board of directors, if the appointment is carrying out by board of directors, yes, they can happily appoint by passing a board resolution. Is it sufficient? Means no. Is it sufficient? Means no. They have to ratify this decision in the meeting of members by passing ordinary resolution. Don't ask what is meant by ratification. I think everybody studied Indian Contract Act. The most loved person in Indian Contract Act is the Pellodu minor. Indian Contract Act provides lot of facilities to that Pellavitra fellow. One of the facilities is ratification not applicable to minor. Ratification not applicable to minor. Say for example, a person came at the age of 15 years, asked for financial assistance, saying that please give me 2 lakhs. I have lot of estates and properties. After 18 years, I will come and sign. Now also I will sign, and after 18 years also I will sign. That means he is ratifying the contract after attaining majority. Is it allowed? No, not allowed. Why? Because agreement itself is void. Not even contract, it is agreement. That is why agreement with minor is void ab initio. Contract with minor, no. As per general sense, it should be called with the name called agreement. Agreement made with minor, void ab initio, not contract made with minor. What is the difference between agreement and contract? Tell me, someone said correctly. Legal enforceability. Very good. నువ్వు కూడా చెప్పావా? ఏమిటో అమ్మా వినబడలేదు. ఓకే, గట్టి చెప్పాలి. నువ్వు మనసులో బూతులు తిట్టుకున్నట్టు అంటే అవ్వదు. సో వాట్ ఈస్ ద డిఫరెన్స్ బిట్వీన్ అగ్రిమెంట్ అండ్ కాంట్రాక్ట్ మా? లీగల్ enforceability. That kind of legal enforceability will never be presented in agreement with minor ma. That is why it will be called always with the name called agreement, not contract. That's a different thing. Okay. Why I'm talking with that minor fellow? Ratification. Listen. Board of directors will appoint MD or WTD or manager by passing a board resolution in the board meeting. Work done na ante? No. Work not yet completely done. There is another work which BOD has to do. What is that another step? What is that remaining work? Means they have to ratify this decision with members in general meeting by passing simple thing, by simply passing ordinary resolution in the general meeting. Ordinary resolution in the general meeting, you have to obtain the ratification. Ratification means approval. Ratification. So you have to get approval from the members in the general meeting. Then appointment is completed. Sir, we appointed some A-class criminal as board of MD, sir. Okay. You are not going through CG channel, right? Okay. We appointed one Ramanujam as MD, sir, or whole-time director or a manager, sir. But that rules Ramanujam appointment which we made in our board meeting by passing a simple board resolution, our shareholders rejected his candidature. Our shareholders rejected his candidature. Our shareholders didn't give approval for the appointment of so-called rules Ramanujam as managing director or whole-time director of our company. Then what has to be done? Rules Ramanujam has to vacate the office immediately. No other option. Ramanujam has to vacate the office immediately. No other option. Why? Because you failed to obtain the approval of members in the general meeting. That means members are not satisfied with your candidature. I'll ask a simple question. Who are the owners? That means you have to satisfy shareholders. But shareholders didn't give approval for your appointment as MD or WTD manager. That means shareholders are not liking you as a person who is holding substantial powers. That is why you have to vacate the office immediately. Sir, shall I obtain CG approval? Nothing. Not needed. So whenever, listen, if members won't ratify the appointment, has to vacate the office. If members ratifies ma, in general, that means members also in agreement, in satisfaction with the so-called person's appointment as MDWTD manager, then appointment gets completed from the date intimate to ROC in MR1 within 60 days. MR1 within 60 days. Kindly remember this form name and days also. MR1. MR1 is applicable for clean recorded persons. How many days, ma? 60 days. How many days? 60 days. In further course of action, you will face MR2 90 days and all. Okay. I'll tell you what is MR2 90 days and all. I'll tell you. So first of all, we completed the process of appointing good persons as MD, WTD, manager. We completed the appointment process of good persons. Why I am saying good persons? They are in compliance with Schedule 5 Part 1. They are not disqualified as per Schedule Section 164, and they didn't enter any kind of composition scheme with creditors. They didn't underwent any kind of imprisonment more than or equal to 6 months. That is why I am calling them as good persons. So good persons appointment is done. Good persons appointment may be done by board of directors or may be done by members. If members appointed, no need ratification and all. Why? Because members are appointing. So from that appointment date, MR1 you have to file MR1 with ROC within 60 days. Why? Because here members are only appointing by simply passing ordinary resolution. So from this date you have to, within 60 days you have to file MR1 with ROC. This is first one. Sir, members are not appointing this good person, sir. This good person's appointment is carrying out by BOD, sir, board of directors. Then what to do? What to do means, he's a good person. He's a good person, but his appointment is carrying out by board of directors. BOD is not the supreme authority for the appointment. Why? Because who are the real owners? Shareholders. That is why BOD is not the supreme authority. Shareholders are the supreme authority. That is why, listen, that is why BOD can appoint, okay, that is a different thing. BOD will appoint by passing a board resolution. After that, they have to obtain the approval from shareholders in the general meeting by passing a ordinary resolution. Sir, supreme authority also said okay, sir. Who is supreme authority? Shareholder. Supreme authority also said okay. That means BR is there, OR is there. From that date, within 60 days, you have to intimate to ROC by filing a form called MR1 saying that we are appointing so and so persons as MD or WTD or manager of the company. Completed. Clear? $50% remaining 50% is there. 50% good persons candidature completed. Now come to bad persons candidature. Simply bad persons mean they are not bad at all, but they are not satisfying Schedule 5 Part 1. That's it. Schedule 5 Part 1. Are they satisfying creator's condition and 6 months condition? Yes. Why? Because if they are not satisfying those points, they are straight away disqualified. They are straight away disqualified. So we won't consider their profiles for the role called MDWTD manager. They are just not in compliance with Schedule 5 Part 1. Schedule 5 Part 1. Sir, I am considering my friend's profile for the MD role in my company, sir. But that fellow is not in compliance with Schedule 5 Part 1, sir. Not in compliance with Schedule 5 Part 1. What am I supposed to do? Automatic route is not available for you. There is a route available for you. That route is approval route. That means you have to take the approval of state government. State government or central government? Central government. వెరీ గుడ్. ఓకే. ఎవరు నిద్రపోవట్లేదా? వెరీ గుడ్. నిద్రపోయే వాళ్ళు పోతానే ఉన్నారులేండి. ఒక అబ్బాయి నిద్రపోతున్నట్టు నాకు ఫీలింగ్ వస్తుంది. ఓకే. సో యూ హ్యావ్ టు అబ్టైన్ ద అప్రూవల్ ఆఫ్ central government before appointing this person as MD or WTD manager. Listen, you are appointing a bad person. That means bad means he is not satisfying Schedule 5 Part 1. You are appointing a bad person as MD or manager or WTD. That is why now the supreme authority is shifting. Supreme authority is shifting. So generally, who is supreme authority? Shareholders. Now supreme authority is shifting from shareholders to central government. From shareholders to central government. Now what to do, sir? Listen. Schedule 5 Part 1 not satisfying. First of all, BR is required. Board resolution is required. That means board level appointment process should be done. After that, SR is required, not OR. Not OR. OR time is gone. Why? Because he's a bad person. He's not in satisfaction with Schedule 5 Part 1. Still we are considering him for the role called MDWTD manager. That is why here in the place of OR, SR is required. In the place of OR, which is required? SR. Special resolution is required. Usually we will pass OR for the appointment of any director, MD or non-MD, whatever it may be, OR. But in this case, SR is insisting. Why the lawmaker is insisting SR in this place? Why? Because this person is not in satisfaction with Schedule 5 Part 1. That is why board resolution plus special resolution in the members meeting is required. Okay, sir, board resolution we got. Members also, special resolution we got. Completed appointment. No, who is the supreme authority? Central government is the supreme authority. You have to obtain the central government approval. You have to obtain whose approval? Central government approval. Why the authority is shifting? Just a minute, ma. ఇవాళ ఫస్ట్ తారీఖా? మంత్ Okay, okay. Listen. Mm, what is our discussion, ma? Schedule 5, part 1, not satisfied. Okay, not satisfied means that person is not satisfying. Okay, very good. That person is not satisfying schedule 5, part 1. Now, what you have to do? First of all, board resolution will be passed. After that, special resolution will be passed. After that, why? Because in this case, supreme authority is central government. You have to wait for the sorry, that means approval from central government. Okay, so you have to file the form called MR2 within 90 days of the appointment. This is the permission asking route MR2 by filing MR2. Sir, whether central government will definitely give approval or not. I already told this point earlier itself. It depends upon the hands of central government. Central government will take multiple considerations in this decision. What is the person's track record? Why? Because if we enter DIN, the person's track record will completely come. What is the company's track record? Depends on that CG may give decision. Okay. So, say for example, central government gave approval, well and good, everything is fine and okay. Central government didn't give approval. If central government failed to give approval for the appointment and all, he has to vacate the office immediately. Has to vacate the office. Okay, sir. Okay, we filed the form within 90 days. Central government will take its own sweet time. After 180 days, after 180 days, CG refuses the appointment. Then what is the consequence? What is the consequence? He has to vacate the office immediately. And whatever the actions done by him so far, if it is good for the company, they will continue. Otherwise, he is personally liable for the activities. Otherwise, he will be personally liable. In reality, shall I say one thing? In reality, after appointment, companies will wait for CG approval. Till that time, they won't even allow that kind of persons to act as MD or WTD or manager. Why? Because if they allow and if he done anything in contravention with the provisions and all, he will be personally liable. That is a different thing. Company reputation will be tarnished, right? That is why depends upon reality, practical situations and all. Okay. So this is what we call schedule 5 part 1, and this is all about appointment. This point I have already told, if I am not wrong. What is this point means? Listen. No, I think I didn't communicate this point. For old batch I have communicated. Why? Because at IRDA point I have communicated. Why? Because chairman of IRDE maximum tenure is 5 years at a time. Eligible for reappointment, maximum age is 65 years. That is why his eligibility is 5 years tenure or 65 years age, whichever is less. IRDA chairman. You will read all these provisions at a later point of time. But listen, we are talking about MD or manager or WTD, right? So for them, MD or WTD or manager, you can appoint we can appoint for a term maximum 5 years in a single resolution in a single term. If you are liking him so much, then you can reappoint. But you can't straight away appoint for 6 years, 7 years, 10 years, 20 years, 30 years. Not possible. Max to max, you can appoint for a period of 5 years, not beyond that. Say, for example, I appoint my friend as MD. He's a clean recorded person. He has a very clean record. I'm appointing him as MD of my company for 7 years. Not possible. Not at all possible. Even though he is having clean record and all, not at all possible. At a stretch, you can't appoint for more than 5 years. Max 5 years is allowed. Beyond 5 years, not allowed. And in case of reappointment, in last year only, you have to think about reappointment, if any. Say for example, this is a very beautiful rule. Say for example, okay ma, I appointed my friend for a period of 5 years. All you guys are crying, no? Why? Because I am planning to appoint him for 7 years. But you guys are saying that Companies Act is not allowing for the activity, and Companies Act is allowing only for 5 years. Very good. For 5 years only, I have appointed my friend as MD of my company. 2 years passed. 2 years passed. How much tenure is left? 3 years. He is really working hard. He is really working hard. Very good. Now, I am planning to extend his appointment by another 5 years. Is it possible? No. Reappointment should be considered only in the last year. That means after the expiry of 4 years, then only reappointment should be made. In the meanwhile, within the time, reappointment should not be possible. Okay, that is why max 5 years at a time. Reappointment should be done only before 1 year, only after 4 years. Sir, how many times we can appoint? Till you get bored of that person, you can appoint. Okay, just like in case of a independent director or small shareholder director, here there is no concept of cooling period. For independent director, cooling period is there after 2 terms. First term appointment, second term reappointment. After one appointment and reappointment, cooling period is there. Ever cooling period is there, but that kind of cooling period concept is not applicable here. You can appoint him n number of times, but the only restriction is you can't appoint beyond 5 years at a single stretch. You can't appoint beyond 5 years, and reappointment should be considered only before 1 year of the tenure, 1 year of the closure of the tenure, or after 4 years. Clear? That is the thing. This is all about appointment, ma. So 410 around. So remuneration, even though we start remuneration now, it is impossible for completion of remuneration. So this is all about remuneration. I think everybody copied, right? Everybody. Okay. So this is somewhat not 100% related in your curriculum, but examiner is trying in one or other way by asking different questions relating to this appointment. Okay. So you have to remember this point. What is schedule 5 part 1, part 2? Part 1 what? Appointment of MD WTD manager. Part 2 remuneration of MD WTD manager. Remuneration. Schedule 2. Okay. In schedule 2, 2 parts will be there. Again. Schedule 5 part 2. Schedule 5 part 2. 2 parts will be there. What if there is profit? What if there is no profit? In that no profit scenario also 2 items will be there, item A, item B. That is why it is a very difficult one. We can't communicate the whole thing in this 20 minutes and all. Tomorrow on a fresh note we can start. Okay. So do you really understand the process of appointing MD WTD manager? I'm talking about appointment only. We didn't started remuneration yet. So I think I can ask questions tomorrow related to appointment of MD WTD manager. Only appointment only, not about remuneration. Okay. So what are the topics we have completed so far? Director, role of director, maximum number, minimum number, types of director, types or classification one and same. Appointment, reappointment, rotation, qualification, disqualification, resignation, removal, remuneration. We are talking about remuneration, but remuneration not yet completed. In that remuneration, appointment only completed. Remuneration will complete tomorrow. After that, remuneration will be completed. After completion of remuneration, powers and duties of board of directors will be there. I think after powers and duties, yes, KMP will be started. KMP will be started. If you are able to complete KMP, only 3 topics will be pending, ma. A, B, C. I'll tell you what A, what B, what C. I'll tell you. So with this, directors and KMP chapter will be completed. I hope everybody is following. Okay. After that, we'll start board meetings and procedures. There are certain attempts where these two chapters only consists of 42 plus marks out of the total question paper. Not saying that in each and every attempt they will ask 40 plus marks and all. But for sure, 20 plus will be there. 20 plus is the bare minimum you can expect from these two chapters. 20 plus. I think I have already demonstrated June 2025 paper, right? Right away, first MCQ. I mean, 5 MCQs related to dieters and KMP. 5 twos are okay. So, very good. We'll talk about remuneration tomorrow. Okay, we'll discuss remuneration tomorrow. Okay, right. Let's end the session here. We'll talk about remuneration tomorrow.